Okay, so thank you very much for joining me again. As I mentioned in the last video, have this new video that I'm making now that's going to go over some of the actual inaccuracies of what's being reported in the media, as well as by certain parties in regards to that investment vehicle that I talked about in my last video. That's been getting a lot of, negative impact. That's putting a lot of damage and risk on the investors. So basically, you can see the presentation I referred to in the last video. You can request it, you'll get a copy, and you'll understand a lot of what I'm going to tell you now. But I'm just going to summarize some of the main inaccuracies that have been out there, because it's very important for you to actually get a thorough understanding of exactly what the real reality is. So one of the issues that they've been talking about is the independent legal advice that many people got when they did this investment. Now they say that investors were not given the opportunity to get their own lawyer, and that a lawyer was provided to them that they were not actually paying for, and they were saying for that purpose that independent legal advice would not have been counted as independent. Now, first of all, I know as a fact that investors were being offered the ability to get their own lawyer that they could pay to get the independent legal advice from. So they were not not given that offer. The second thing is the actual lawyers who spoke and provided the independent legal advice, they weren't actually telling people to invest or not to invest. And their main job, and what I saw them do, is they would go through the Form 9D, which is the Law Society form, and it's basically a structured form, and it would go over the specific details of the investment that, on a general standpoint, that investors should understand. So basically the start date, the end date, the rate of interest, the frequency of payment, certain terms and clauses were in there. And basically the lawyer was making sure that he explained or she explained those specific terms and clauses to ensure that the investor had got that disclosure and had that understanding. Now, the ILA lawyers, from my understanding, were paid regardless of if the investor chose to invest or not. So they didn't have a vested interest to sell the investment or not sell the investment. I mean, pretty much they weren't giving advice. And I know the advice they gave was mainly not advice on investing, but mainly going over the points of what certain things meant and the terms of the actual investment that were disclosed on that 9D form. So when people say that they weren't getting this proper advice, well, really, if an investor asked them if they should invest or not, the lawyer never actually told them yes or no. They basically would say, well, we're here to make sure you understand these key terms and the structure of the investment as per that form, and that's pretty much where it was. Now, I'm not making a determination of yes or no if who should pay for that cost, but all I'm saying is, based on what I witnessed, I don't think where the money came from actually made a difference on the actual result of that process. Now, David Franklin, the lawyer who is out there, making claims against this and putting out a lot of inaccurate information and picking and choosing certain things. Like, he pretty much said that, oh, there was a publication that came out from the Law Society and saying that these lawyers should not have been providing this independent legal advice if they were not being paid by the investor. Now, the publication he's referring to came out in October 2017. At the time, the independent legal advice was not being provided automatically to all the investors. They were given the option of getting their own lawyer, but at that point, they'd actually stopped having these lawyers, who are not paid by the investor, do these independent legal advice, meetings or calls. And that publication came out, but the way Franklin's trying to say it is like, oh, that publication's there and these people were not doing it right. But the publication came in after the fact, and it was a publication just basically, telling the lawyers who provide these independent legal advice to ensure that it is indeed independent. And really, the timing of that publication compared to when it was actually being done didn't really even correspond. So they're just trying to, Franklin's just trying to use that to confuse people again, just like he's been doing, what it seems like he's been doing with a lot of the other information out there as well. Now, certain posters on the forum and the common board that I had looked at to kind of come up with what I'm talking about today were actually making claims that every investor that invested any money in any of the projects within this vehicle are all going to suffer a total loss. Now, again, as I talked about before, there were 80 projects roughly in total, 30 of which have already been completed and paid back, all the money, principal return and everything. And there's certain other ones that even now, after in these challenging situations that have now come about after this, last couple of years of what's been going on this fiasco, there's still projects that are paying out money, and there's many of them that are actually not really impacted. I mean, there's like all of them will have some impact, but the ones that are mostly impacted are ones that either were in need of funding last year when the funding restrictions were in place, or projects that had already gone past, I guess, maturity date, and now they're still trying to get things done. But obviously, they all had an impact from what's been going on. But there's certain projects that still have some time to go or didn't actually need funding, as urgently last year as some of them did. So some of these may still be fine. So for them to go out and make a definite claim that it's a total loss and all the money is gone, well, that's very irresponsible to do that. The other thing is many people on this forum, or even some of the people that are supposed to be industry people that have been talking against this, are basically claiming as a fact that this whole thing was fraud from the beginning. Well, if that was the case, I mean, the regulator completed a complete review and a settlement that basically said that there was no contravention to the act. And at the same time, the RCMP has been looking into this for the last 2 years roughly, and to date there still hasn't been any charges. Today is December 27th, 2018. So, up to this point there still hasn't been any charges. Nothing's been proven in court. It's not gone through the court process completely. The investigation's not completed. So for anyone to make those kind of claims, that also is very irresponsible. Now, again, we talked about how certain people are trying to sell the idea of having multiple class actions done. Now, multiple class actions on false pretense can end disastrously for the investors. I mean, so just be aware of that. Make sure you know the information you're using to base your decisions on. Make sure you're getting the full information, not just clips of it or pieces of it that's going to make you, sign up for one of these kind of cases. Now, we talked about this in the last video about how David Franklin had done an article a couple years ago claiming that $1 billion was going to be lost in syndicate mortgages, and pretty much after making that claim, he seems like he's done everything that he could to make that a reality. He talked about, we mentioned in the last case as well, about how he tries to justify that just because the RCMP got a warrant from the judge, that means that there's judgment already done, when really the warrant's just there to allow them to go in and collect data that they can then use to see, was there something that they can find that proves that there was fraud or not. So they're just going through that process. But when he's trying to say that because they have the warrant, it means something is wrong, almost saying that means that there's guilt and there's a judgment already just because the warrant was made, that's not entirely correct or true, and that's one of the things that he's been saying. Now, a lot of the stuff that we've been talking about, we talked about some of the inaccuracies already, a few of them, and you can see some of them are pretty major. So, those things, all they do is fuel more damage against the investment, which basically adds more risk to the investors. And that's really what's happening. Those are the people that are going to suffer the most and that are suffering the most with all of the stuff that's happening. And that's why, I find it very hard when a lot of these people that, someone or people are pointing out facts to them and they're not willing to even accept or listen to the fact, and they'd rather just attack the people to try to provide information. That's really, what happened, with myself. Like initially I was posting on this, anonymously, and not necessarily because I didn't want people to know who I was. I mean, it was just a matter of, I was building, as I mentioned before, the email address was investorvoice@hotmail.com. So I was building something under the name Investor Voice to basically have people understand, what we were standing for, what we were doing. And then, David Franklin, the lawyer, when he realized I was putting out some information on this forum that could affect, what he was trying to push, he basically, named me, put out my license number, my mortgage license number, and then he named every individual in the brokerage that I'm connected with now, even though the majority of them aren't even involved in anything. None of them are really involved in what I've been doing by putting this together. I mean, my whole focus is to get information out to investors so that they get the full story and they're able to make the right decisions based on the factual information. So, by him then trying to name all these people, I mean, all he's trying to do is he thinks that if he puts my name and license out, I'm going to be afraid, and maybe I'm not going to stop, doing this stuff and talking about this stuff that's putting pressure on what he's trying to sell on his end. And at the same time, naming these other people, he probably just thinks that maybe if they are worried that they may be affected, that they may try to stop me from continuing doing what I'm doing, which obviously will help him get his end as well. So, it doesn't really, that's really what anyone's looking at will see, that's what he's trying to do. I mean, what difference does it make what my name is if I'm trying to point out factual information to people that are, not getting the whole story, right? So just kind of keep that in mind. Now, one of the things that they always talked about is they said that there's a lack of disclosure and that people were not informed about a lot of things with this investment. Now, I've been involved with many products, many services in the financial industry, and I've seen the paperwork and the disclosures that go along with a lot of these products, and I've never seen the amount of paperwork and disclosures and the added disclosures and changes that just basically increase the paperwork more and more and more over the years. I've not seen so much, and it's funny because a lot of the investors that actually go through this process, they also kind of say, well, whoa, there's a lot of paperwork. I mean, they've never seen that much paperwork before. I mean, it's more paperwork than people, go through, and they even, buy their own homes and do those kind of things. So, it's not about just having paperwork, but the paperwork, you go through it and you sign all these documentation and you go through the process with them. I mean, I know myself personally, when I sat with investors and went through the process, it was typically between 3, maybe even 4 appointments, and roughly, cumulatively, at least maybe 6 to 8 hours, if not more, of going through paperwork and going through the disclosure. So when they say it is not a disclosure, there's some problem with that claim. I mean, some of the things that they talk about. I mean, we talk about the extension provisions, different reasons why projects can go longer than anticipated. We talk about certain provisions that if certain things happen that's outside of the control of developers, what options they have available and the time frames there. We talk about the priority of who's on title in what position. There are certain people that make these claims that they were not aware that they were in certain positions, but that was all clearly on all the documentation. So, these are certain claims that aren't actually factual, but, a lot of people are buying into what people are saying. Maybe they don't remember, maybe it's been a few years, or maybe, they're upset about the situation, and it's very easy for people to kind of manipulate them with information that's not entirely accurate. So that's really, what seems to be happening over here. I mean, it's easy to get misinformed people angry, with selective information, and then try to take advantage of them, because they're in their anger. Obviously, they're not thinking straight, and that's affecting their decision making. And that's really what some of these people are trying to capitalize on. Now, one of the other things that recently I've noticed them talking about is they talk about one of the trust companies that were being used, Olympia Trust Company, and basically David Franklin and some others are selling the idea that Olympia Trust Company was never allowed and shouldn't have been allowed to do any investments or hold any money or investment accounts for anybody in Ontario, and that's actually not true. So what the actual fact is that Olympia Trust is not allowed to actively market and advertise their services in Ontario, but they're allowed to hold accounts for Ontario residents, and they don't only hold accounts for residents in this particular vehicle, they also hold accounts for Ontario residents for other investment products and other self-directed investing. I mean, there's a lot of exempt market products that Ontario clients deal with, and they actually, many of them use Olympia Trust as the trust company that they use for those investments as well. So a lot of times people, they're just telling you that this company went out to Olympia in order to get them to have this investment account, and they were never allowed to do this, and that's not right. Now, July 2017, new rules came in effect saying that Olympia Trust can no longer hold accounts for syndicate mortgage investments and in Ontario, and that's really when that change occurred. But prior to that, there was no issue, and even now they can still hold accounts for Ontario residents that are not in syndicate mortgages and other self-directed investments. So again, just make sure you're aware, because again, it's not accurate that they're doing that. And just think about, they're trying to sell class action lawsuits against Olympia Trust with that being the reason why, when that's not the reason they're giving, is not the actual fact. So just make sure you kind of dig into it and make sure you understand exactly what they're saying and what's right and wrong, and don't go into a suit where they're based on inaccurate information, because that's just going to come back and bite you. Now, there are many posters online that have been claiming that they've lost all their money, and in some cases, these project is still ongoing and the losses are not defined yet. It's not complete or finished or definite. Sure, there's delays, there's extensions, and in some cases that was some of the standard risk, but in other cases now, because of all this added pressure from all the other things that we talked about in the last video, it's making these projects have more challenges, and in many of these cases, if they're able to find a solution, those solutions sometimes will take time, right? So this is basically why I'm saying in some of these cases, they're not actual definite losses. So for people to actually, come to that conclusion that they've lost when it's not being provided to them as a loss yet, I mean, it's a little bit premature to do that. And, it's not in your best interest to actually do that, right? So just be aware of that. And the disclosure form. So we talk about the disclosure forms here, and the reason why I'm going to talk about this is the Financial Service Commission of Ontario had a set of disclosure forms that investors went through, and the people that were responsible to make their disclosures on that form were actual mortgage brokerages. So basically, BDMC was one of the brokerages, the brokerage that actually was representing the developer in the transaction and closing the transaction. And then there was different brokerages that represented the investor. Now, both of those are brokerages, and they are responsible to disclose, their fees and any conflicts of interest or any of those kind of things in the disclosure forms. Now, Fortress Real Development, which is, they were not a mortgage brokerage, so they didn't actually have disclosure requirements on that disclosure form, right? So going into this, like, many people are talking about certain fees being disclosed or not being disclosed. Now, anyone that looked at any of these disclosure forms, it would show the fees that BDMC would get as a brokerage. It would show the fees that the other brokerage that represents the investors got, because that was all disclosed in that document. Any conflicts of interest that these brokerages had were all disclosed there as well. Now, Fortress Real Developments, not being a mortgage brokerage, didn't have a requirement to disclose their fees on the actual disclosure forms, just like the architects in the project or the the engineers in the project or the people that put up the windows and whatever. None of those companies had to disclose their fees on that brokerage form. So the development consultancy agreement fees that Fortress had with the developer was pretty much just like any other cost of the development that the developer had to go through as part of the project. So these additional costs weren't required to be on the disclosure form. But there was schedules at certain points in time that even though Fortress Real Developments didn't have to disclose their development consulting fee, they still had a schedule saying that out of the advance there would be funds going as a development consultancy fee to Fortress Real Development. So it was being disclosed. It didn't disclose the percentage, but it did disclose that there was a fee there, and that it did disclose that there was a development consultancy agreement that, you know, again, any brokerage or investor, if they wanted to, they could have requested to see that documentation to kind of ensure, you know, see whatever the fee was there, right? So that's another thing. You know, they talk about these fees that were not being disclosed, but whatever fees that were required under those forms were being disclosed, and other fees were voluntarily being disclosed, that there were in fact fees. May not have disclosed the actual dollar value percentage, but it was there. Another thing people talk about is the amount of the fee. So basically, out of the money being raised, you know, there's this talk about 35% going to Fortress Real Developments. Well, really, that's not entirely true, because out of that money, part of it went to BDMC as the closing brokerage, part of it went to the other brokerage, and that fee then, some of it went to the agents, some of it went to for the office and the expenses of the brokerage. You know, so there was many people got part of that fee. It wasn't all that fee to that one company the way they're kind of portraying it. The other thing is that the project had a certain project budget, which was this much. The syndicate mortgage that money was coming through was this much as part of this entire, you know, project. So the fees that were being paid, like even the fees that were coming out to the development consultant fees or the brokerage fees, those fees were basically, if you were to express it as a part of the entire budget, it was very small, but as a part of the actual funding, it was larger because the fee was just coming out of that funding, but basically it's part of the entire project budget. So, you know, you have to kind of look at that. It's not like the entire project was this much and this big chunk is going for fees. It's the project budget was this much. This portion only was what represented the syndicate mortgage, and of that, some of those board funds were used for these other fees that were part of the entire project, right? So you got to kind of get that understanding clear as well. Now, one of the other things that people don't realize or aren't understanding is, if out of the money raised out of the syndicate mortgage, if 35% were the fees that went through, you know, went out to these other parties, and 65% went to the developers signed an agreement to borrow these funds. They had their accountants, their lawyers go through all the documents, all the paperwork, and at the end of the day, if they were agreeing that 35% of that loan went towards these fees and 65% is what they would get, or whatever the amount they decided they would get, they knew what they were getting, and the only reason they would have taken that deal is if it still made business sense, right? Now, if they were thinking they were going to get 100% of the money and they only got 65%, they would have said something. They knew that this is the amount they're borrowing, and out of those borrowings, they knew they had some fees there. Now, they could have got those fees from any of the other funds they were borrowing for the entire project, but they chose, okay, we want to take these fees from here and use this, and we're okay with getting this difference. It still makes financial sense for us, and our project's still going to work and still going to be successful. And that's why some of the developers did it multiple times. It's not like they, you know, got this money and then didn't know that they were just going to get part of it, and then all of a sudden, like, why would they not only take that deal, but why would they take it again and again and again for different projects? I mean, this is some of the things people need to understand. They knew how much money they were going to get net of whatever the costs and expenses and fees and all were there, right? So that's something else just to be aware of. Yeah, so another thing is, in many of the cases with these projects, the developer wasn't actually supposed to pay the interest out of their own funds. In many of these projects, basically they were borrowing the money, and some of the money that they borrowed would be put into a separate account called an interest reserve that they would then use that money to make the payments of the interest monthly or quarterly or whenever the interest payments were due to the investors. Now, there were certain clauses that basically said that they were allowed to use those monies either, you know, if something were to come up, say that would put the principal at risk, at that point, you know, it may make sense to actually use that interest money to keep the project going and preserve the capital and principal and keep it moving forward, rather than continue to pay the interest and have the principal be lost because something failed. Like, for example, say if all of a sudden they needed funding, but they didn't raise enough money, they were short in raising the funds, or maybe the funds took longer to raise, and all of a sudden there was an expense that had to be looked after at that point, and if they didn't, it could put the project at risk. And in a situation like that, it may make sense to use that interest or that money that was left aside for the interest to get through that cost, and then have the interest accrue, so that way they're still growing money on the interest, but the project still is being secured and kept safe. Now, in many of these projects as well, when money came into these projects, it came in at different stages. They didn't all come in at the same time. So each time they raised money, they had to put money in a separate account. So if at any time there was delays in raising the funds, or they couldn't raise it fast enough, during those periods of time, they could accrue the interest, which means that they're still calculating that money against your principal for the period of time that your money's in until it's complete. And at the end of the project, if there's sufficient funds after all the expenses and everything in the project, then you would get your principal and that accrued interest. So, there were clauses in this that allowed some of these, but many are saying online, or people are telling people that this interest was used for other purposes, or it was never supposed to accrue and it was always supposed to be paid. I mean, and that it should have been paid by the developer. I mean, these are all things that are not always completely accurate. Each project was different, so you have to look at the paperwork for each project to see exactly what the terms were on those projects. Now, there was another claim that some people are making, basically saying that Fortress and the brokerages, were basically training agents to specifically go after inexperienced investors to sell this product to, and unsophisticated investors, and that's not actually true. So Fortress was basically involved with the developer, so sometimes as a co-developer, sometimes as a development consultant, and basically the brokerages, whether it be, there was a few of them out there, and they had different agents. Now these agents are all independent, agents that have their own client base for the most part. I mean, certain clients would call into the brokerages, and they would then assign those clients to certain people that actually were employed by the brokerage. But for the most part, most of the agents involved were independent financial people that had their own client base and basically went to their own clients. And then as part of that, they not only showed the product, but they had a detailed know your client process, a detailed risk tolerance process to go through to ensure that the clients fit within the investment and based on what their goals were and so on, just like they do have in any other investment vehicle as well. So those detailed processes were being done and were gone through. And on top of that, on a lot of the disclosure documents, it did mention specifically that this was a high risk investment, that you could lose all your money. It's not insured by the government of Ontario. All these disclosures were there, and basically a lot of people are saying that this was sold as a safe, guaranteed investment, and that's not actually true. And if any agent did sell it and tell you that it was safe and that it was guaranteed, then obviously they were in the wrong, and that's a problem. But that doesn't necessarily mean that that's how the investment vehicle was. The other thing is that when people say that the investment, that you're secured on title, does not equate to safe or guaranteed. That basically is just defining a fact that your name is on title to the project. You have some security on that title, but that doesn't necessarily mean that it's safe or guaranteed. I mean, there's two separate things. One is a fact of what's actually there, and one is explaining the security of or safety of the investment, whether it be low risk or high risk. So secured on title doesn't mean low risk. Like those are two separate things altogether, right? So just if anyone told you it was low risk, safe, guaranteed, then obviously there's some challenges there. But it clearly did say that it was a high risk investment, and it did define all the different types of risk in the disclosure forms as well that could affect the investment. Now, one of the other things that I've been seeing as well recently is with regards to David Franklin's claims that this investment, that they were using valuation methods that were fraudulent. And here's a problem. So when I looked at the Financial Service Commission of Ontario and their regulation, there wasn't any specific regulation as to what type of valuation was required. Only in July of 2017 did they make these new rules now that they have to be AACI appraisals, but before that, that was not defined in there. And it didn't mention, like on the actual documentation that was presented to investors, it did disclose what type of valuation it was. So it explained what the assumptions were and everything as well, and it didn't say that it was an AACI appraisal. So it's not like they were giving one valuation and putting another name on top of it. It was disclosed as it was, and within that time frame that it was used, there was no specific regulation within the act saying what type of valuation. And there's various types of valuations that are used in the industry. The other thing that also that he's trying to say is that, and he's gone to the RCMP with this, and this is part of their fraud claim that they're looking at, is he's saying that the investments were sold as RSP eligible and that they weren't, because in order to be RSP eligible, it has to be within 100% of the value of the property. But even in the CRA, from what I've seen, it didn't specify what type of valuation. It just says valuation. It doesn't even say the appraisal in the CRA regulation. It just refers to the term valuation, and it doesn't specify what type is used to say whether it's one that will be used to qualify or not qualify the investment. So that's another thing, with those not being defined in either of those areas, it's hard to really say this is right or this is wrong. Now that it's defined under the Financial Services Commission of Ontario, under their new rules on syndicate mortgages, it's a different story, because now at least it's something that's there, that's defined. Just to clarify, I may have mistakenly said July 1st, 2017 was the date when FSCO, the Financial Services Commission of Ontario, created the new rule about the AACI appraisal for syndicate mortgages. It's actually July 1st, 2018. So if I had said 17, that was a mistake. It's July 1st, 2018. But yeah, but everything else I said in that section stays the same, except for that one date. Now, certain people have been mentioning that certain other disclosures were not there, with this investment, and a lot of them are talking about disclosures about the, past regulatory issues or concerns with some of the principles of Fortress Real Developments. And actually, those disclosures were there. There were disclosures being made about both the MFDA as well as the OSC past issues that were unrelated to the syndicate mortgage, but it was there, and those disclosures were there amongst with, we've talked about before the number of disclosures here when it comes to comparing it to other investments. Like here, even the lawsuits or any lawsuits that were active and open were being disclosed throughout. So even the cases that we talked about earlier that David Franklin and some other law firms were involved with, those cases were all being disclosed while they were open cases in the courts to the investors that were investing at that time. So, these are, when you look at the most traditional investments, when you're investing with a bank, you invest with an insurance company, you invest, through different, financial companies. And in many cases, a lot of these companies have lawsuits against them. Some of them are active. They've had to pay fines and make settlements for various things, but none of them, very few of them, if any, actually disclose any of that or are required to disclose any of that. So, at the end of the day, it's like, when this is doing whatever it's doing, if you're really gonna put pressure on it, it should actually be fair for everyone. So pretty much every vehicle or every investment should be living up to the same standard. You can't just kind of, put a microscope on one area and say, okay, you have to do this, but no one else has to. It should be, everyone should equally be responsible for disclosing all of that, because all of those disclosures would have an impact on whether or not people choose to invest with that company or not. So at the end of the day, just to be fair, it should be like that across the board for the benefit of all investors. Now, there's that false belief, in the industry that, even under the regulation and with regulatory bodies, that traditional investments, which is basically what most people do, is safer, and that's like the assumption that many people make is just because they feel like, okay, so many people are doing it, so there must be a certain level of understanding in those vehicles, and which is not entirely true, because I mean, there's many people that invest in mutual funds and in stocks, but not all of them can really, are all at the same level. Not all of these people understand in the same way. So you can't just make that assumption that yes, just because most people do it, that it's safe or easier or better to understand, or that people have that base level of understanding of it, because there's a lot more risk factors with some of those investments, a lot of global risk factors that are there, that it's very hard to really define and explain every type of risk that will affect any of those investments as well. And not everybody that invests in them understands or even knows how to explain how some of those investments work. And with the disclosure requirements being so minimal in those cases compared to something like this or some of the alternative investments, other alternative investments out there, it's not really right to have that assumption that just because so many people do this that everyone knows how it works. I mean, and I think there should be more disclosure in those areas as well, just to be fair and to protect all the investors that invest in all types of vehicles. Yeah. Now, there is lack of regulation in this, and that has been an issue. I mean, as soon as this started getting substantial growth, even before that, the regulator, the Financial Services Commission of Ontario, should have enacted certain I guess uniform disclosure and uniform requirements that everyone in this specific space have to follow, and that would have saved a lot of issues, protected a lot of people, avoided a lot of problems. And the thing is that not only did they not do it at that point, but even once they started getting complaints, whether they be complaints that were justified from investors or complaints from these other opponents that were filing complaints, either way it was complaints. So that should have triggered something to say, okay, you know what, to ensure that we are not getting these complaints, or that we're making sure that we're protecting people, or that everybody that's in the industry is doing the same thing and the same uniform processes are being done for the best of the general public, we should have put these regulations in place. So the regulation was lacking, but at that, you can't really fault on the businesses or companies or brokerages that were acting within that regulation. So as long as the rules were being followed that were in place, you can't penalize them. And it's just like in any regulated industry. I mean, there's many businesses that fall into various types of regulated industries, and their job as a business is to make sure that they're doing the best for their business and act within the regulation. And many people that are in regulated industries, regardless of what the industry is, will work at the maximum level of where they can get as much done and at the same time be within the regulation. Now, no business is actually, has the onus to actually act above and beyond the regulation. So at the end of the day, the regulation is what has to be in line and in place to make sure that everything is being looked after for the best of the public. And if there's any gaps or spaces or areas that are missed, the regulation should actually get that and make sure that's in there to prevent anybody to kind of be working at that level where they're right on that borderline. You know what I mean? So that's all the regulator's responsibility, and you can't really fault the business to kind of act as long as they're acting within the rules that are in place. Now, one of the other things, and I'll touch on this is actually one of the last things of the other things that I kind of went through already, but there's been certain parties, as we've already talked about, that are opponents to this, and for many years. And again, I don't know, they all may have different reasons why. I don't know I can't really, I'm not going to speculate into any of that. I mean, that people can find out on their own if they want to look into it. But basically, what happens is, when there are many people that have been saying a lot of things that are not accurate, some things that are, you know, false. People have been making claims, and people have been saying things online on social media. Some things have been said in the papers, and you know, in some cases, different companies have gone out to actually challenge some of these individuals and pretty much block them or try to block them from putting out more false and inaccurate information. Now, every business and every individual in Canada has the right and the ability to actually defend themselves from libel and defamatory, you know, remarks and comments that could affect them, their person, or their business. And when some parties did take those rights and try to, you know, utilize those rights and enforce, you know, what they could enforce. Basically, people were out there saying that, oh, they're, you know, we're able to use like high-priced lawyers to block people from talking, and if they hadn't blocked those people, the situation would be a lot different. But that's not actually correct and true, because at the end of the day, you know, if someone's saying something that's false and inaccurate, they shouldn't be able to do that, because that's going to cause damage to a business or a person, and that's why everybody has that right to defend themselves from that. Now, you know, you can't just pay a lawyer and go to court and then shut someone out, like shut someone down and keep them quiet just for the sake of it. I mean, if you have to go to court, you know, to do that, you have to prove to the judge why what that person is saying is, first of all, if it's true or not true. I mean, if it's inaccurate or false, you have to be able to prove that. And second, you have to prove that by them being able to continue to say that, it's going to add damage to you as a person or your business. If you cannot prove what they're saying is inaccurate, and if you cannot prove that it's going to cause damage to you and your business or your person, the judge won't just block that person from talking or speaking. So you have to prove that it's false and prove that it's causing damage, and only then will the judge block that person from doing that thing or saying that whatever they're doing or saying or doing or spreading. So at the end of the day, it's not a fact that you can just pay someone to go shut someone up. No, you have to go through that process. And again, if you look at the court records and the documents, you'll see what processes were went through, and you'll see in some cases some of the things that were being complained on were not actually blocked by the courts, and some were. So that kind of shows you that yes, you can go ahead and you could say that I think that this person is saying this, it's all wrong, and this is going to cause damage. But now you have to prove that. If you cannot prove that what they're saying is wrong and that's going to cause damage, then those particular items that you cannot prove that way won't be allowed by the courts to be blocked, right? So, you know, people need to understand that and not just jump to, just, you know, a lot of people, like even these lawyers that are making these claims, they know the law, they know the facts, but the fact that they're saying this, they just want to confuse people. They want to use that to kind of, you know, get into people's heads, right? And that's why you need to make sure you understand, and you can't get, you know, pulled in different directions by these people that are trying to play games with you. You need to be informed yourself, right? So that's very important. And you know, we even talked about in the presentation that I mentioned before, if you actually get a copy of that, it'll actually talk about a recent procedure that's being used in the court. You know, it's called anti-slap, where certain individuals are being allowed, you know, to say something, even if it may not be 100% accurate, as long as they think or it can be, you know, construed to be in the public interest. So, you know, it's getting harder and harder to do what these people are saying, but, you know, you can't just pay a lawyer and shut someone up. So, you know, make sure you look at this presentation we talked about before in my last video. Again, I'll mention it here again. You can email investorvoice@hotmail.com. You'll get a copy of that presentation. It will go through a lot of the stuff in both videos that you're seeing now, the last one and this one. It will show you a lot of information. There's a lot of supporting documentation. The main thing, again, I'll say it one more time, from all the stuff I'm doing, is to make sure people are informed and people are aware of exactly all the information they should have and they should know in order to make the right decision for themselves moving forward in this. There are actions that many people are trying to take. Some people are taking these actions, you know, who knows what the main reason is, but if they open multiple actions in multiple directions, they are ensuring their fees, but they're also ensuring a higher risk of loss. The more cases that are open, the more chances are that you can have cases that fail, that will then leave you as the investor who's the plaintiff to be responsible to pay for the cost for the party that's successful in that case. So just make sure you're informed, make sure you're aware, question what you hear from everyone, find out what they have to gain. Again, if you have to ask that of myself as well, by all means go ahead and do that. That's your right to do that. But look at the information from all parties and see which information is giving me the best information that I can use for my best benefit. Okay, so I appreciate your time, whoever it is that sits through and watches this. The people that are not going to be happy from what I have to say, again, I'm sorry. It's just just like some people are not happy about what you've got to say, you're going to be unhappy with what I've got to say. But at the end of the day, the people that matter most here are the investors, and they're the ones that should take pieces from what you have to say, pieces from what I have to say, and kind of look at all the details and say, okay, what makes sense out of all of this? And they should have that ability, and they should be able to get this information too, not just the information that you want to give them. And I'm hoping that at some point, some media will want to take the lead and basically bring this out. Because see, at the end of the day, through the presentation I've put together and through these videos that I'm trying to do, people are going to get informed. Now, the average person reading the newspaper doesn't really care what you're writing about, but the investors do. And when these investors get this information and they read the papers and the articles and they see exactly what's being written there and how not the whole story is shown, they're going to have questions. So the first media source that's going to jump out there and say, you know what, we need to make sure we get this whole story told, that's going to be the one that's going to have the least amount of questions to answer from these investors. And a lot of people in the industry, when media gets in, and when lawyers and all these things happen, many people just kind of back out and back down because they say, well, you know what, I don't want to get involved, I'll just move on to the next thing and forget about this. And at the end of the day, that's wrong, because that just allows this kind of thing to continue and continue. What's happening here is this is not the first time this has happened. It's happened with other businesses, other investments, other industries, and it's caused damage and loss for investors or people out there. And the more we allow it to continue, the more it's going to happen. So even people in the working with other alternative investments or in the exempt market space, they should also be aware of what's going on here, and they should also be making sure that people always make decisions based on all the data and factual data. And they can't just say, okay, this is just a thing with syndicate mortgages and fortress, and we're okay doing our thing. Because at the end of the day, your product could be next. What you've been working with, what you've been putting your investors in with good faith, thinking that knowing that it's a great product, it's going to work great for them. All of a sudden, someone can come in there, or a regulator can come in there, and they can actually be the greatest risk to the investment. And no one would think that the regulator or some people in the industry, or even like some of these lawyers, you could not think to have a disclosure document to name individuals or people or regulators as being a risk to the investment. I mean, typically you talk about different types of investment risks that are, standard risks in each product, but now these are other risks that can come in, that even a product that's working well, that's paying people, good returns and, getting their money back, doing their job. I mean, albeit with certain risks that are there, which are going to be there, but at the same time, even ones that may be working fine, that you can have all the faith in, and with good faith put your clients in there, you could be affected as well. So make sure that you don't just put this to the side and move on with your own thing. Make sure you take action when things like this happen to prevent this kind of stuff from happening, because the more it happens, the more it's going to put your investors at risk, and more people are going to be at risk of losing money, and it affects the entire industry, right? So again, one more time, I hope you take this information seriously. Hope you get something out of it, and I appreciate your time. Thank you very much for joining me, and I wish you all the best. And our main goal is to make sure we can, wherever we are at this point with this, we want to get the most positive result possible. So that's our goal, and hopefully we can get there and keep you protected while we do it. Thanks very much. Take care.